everyone, I'm Raylene Schifano with HOA Fightclub. I make these videos to help educate consumers prior to purchasing into a condo association, and also to help people that are already in a condo association understand the laws and the rules and the CC&Rs that they've signed into. So this week, I have been doing a lot of stuff. It's been a very busy week. We're kind of getting to the end of the legislative session where the laws are being passed. And in Washington State, House Bill 1482 has made it through both the House and Senate and is headed off to the rules so that it can become a law. So this law will help people that are being foreclosed on by their association. The association is going to have to prove that you were 3 months past due in your assessment and wait and give you notice before they can foreclose. They're going to have to prove that you are being foreclosed on for your assessments only. If an attorney or the board puts liens on your homes and tries to foreclose, they're going to have to prove that you were actually past due on the assessments, not including late fees and attorney fees or any other fees that are added. They can't put liens on your homes if it's just for fines. Fines are really kind of tricky because there's no actual due process offered. So homeowners shouldn't lose their home for fines and fees. That is a volunteered neighbor that is the board, and they are jury, judge, and executioners. So really trying to push that we have rights in Washington State, and the legislators have heard us. There's also legislators that don't have their rights, and they are kind of frustrated too with the system that we have in place right now. So I think in Washington State, laws are going to start changing, hopefully for the better, to start protecting more homeowners. Nobody should lose their home. That's cruel and unusual punishment to allow their neighbors to foreclose on them, because you don't know if that neighbor has has grief against them or whatever. So we want to make sure that everything is fair and equal in Washington State. So then the other thing that I've been doing this week is a lot of homeowners have been dealing with their property managers and boards denying their requests. So records, you have the right to every record of the association. Now, you don't have the right to executive minutes, which is legal. So if they're suing a homeowner, you don't have the right to know who they are suing. You may have the right, though, to know who that the association is suing someone. The board shouldn't just be able to sue every random person. They should have to be able to establish why they are suing someone with the other homeowners. So you want to be involved and know what the board is doing. They shouldn't be making decisions outside of the board meetings. All decisions and votes have to be held in a board meeting. Now, they can talk about things through email, but they actually have to bring that back and vote on it in front of the homeowners at the board meeting. So if they're not doing that, that is a breach of their duty. So you want to make sure that you're involved in those meetings. The other thing I had was homeowners making a request and the property manager coming back, and this homeowner's had some complaints about his neighbors who are tenants. They're not actually owners. And if you're in a condo association or an HOA, usually only the owners can approach the property managers. Your tenants are third parties, so they're not allowed really legally to have anything to say to the property management company or the board. They really don't have to take in some of those complaints. But this property manager has, and they are saying that it's the owner that's the problem, and they want the owner to go to mediation with the tenant. Well, that's not the way it works in HOA. So you want to make sure that your rights are being defended. The other thing that I noticed in the letter from the property manager was the property manager accused this person of harassment or potential harassment. If the property manager has stipulations, if you make a complaint, it has to be in writing. If you constantly see these problems on your property, you have to keep turning those complaints in. That shouldn't be considered as harassment. That should be considered as a homeowner trying to do what's best to protect the association. Property managers are not on site most of the time, so they don't see the violations that are happening. And we also have volunteer boards that don't have time to always see every little detail that might be going wrong. So if you have a rule in your association CC&Rs and somebody is violating that, you want to have proof of the violation, which is usually a picture or a video, and you want to send it to the property management company or the board. Now, if you make those complaints and those are actually valid rule violations or CC&R violations, the property manager has the responsibility, and so does the board, to cure that and make sure that the tenants are in compliance. So the landlord is responsible for getting his tenants into compliance. And if they're not, then that board should be following the rule violation procedure and finding not the tenants, but the homeowner. Then the homeowner would make sure that their tenants are doing the things that they are supposed to do. Allowing tenants to get out of control is one of the huge issues in Washington State that owners of condos especially, but it does happen in HOAs too, that these tenants don't take care of the properties and they're not doing what they're supposed to be doing and they get away with it. It still should work the same. You can't collect from a tenant, but you can collect from the landlord. So we just want to make sure that the owners are being protected, and that property managers aren't using harassment to deter their job, and they have a duty to protect the association's interest. So if a tenant is causing problems, that's not harassment if an owner is turning them in for violation of the CC&Rs. What if the other thing was drones? They don't have power over drones. And then he was accusing the same person of harassment because he was videotaping. This is the day and age of videotape. The doorbell rings, the drones, the cameras on us all the time, our cell phones, people are videotaping you. And if you're in public and in common areas, you do not have the right to expect privacy. So the property managers should not be making accusations of harassment. They should be doing their jobs. Then there wouldn't be a reason for the homeowner to make complaints if the other homeowners were in compliance. So we should have open communication with our property managers and our boards. I know that in this property, the board has no open communication with the homeowners, which I think is really, really weird and wrong. The board should be held responsible and liable for what they're doing. They wanted to go through the property managers because the property managers are held harmless, and then the board can say they didn't do it and the property manager can say they didn't do it, and everybody's held harmless. So we need to protect our rights and know the laws, know your CC&Rs, and know what's right. And if you have any problems, you can send me an email at hoafightclub@gmail.com and I will help you. Have people subscribe to this channel, have them get on here and watch the videos. And if somebody's having issues and they want me to make a video for them, have them do that. Have them send me an email and let me know what they would like to know. CC&Rs can be sent to me real easy at the same email address, and I will go over them for you. If you're a real estate agent, I will look over CC&Rs for your clients to red flag any potential issues. I think that real estate agents get blamed for a lot of the issues in HOA because their clients, the first person you blame, which I did, I blamed my real estate agent for the lack of protecting me by not realizing that I had been given a fraudulent resale cert. And my real estate agent should have known that. They should know what they should be looking for. And if they don't, they need to be educated on how to protect their clients. All right. I'll see you on the next one.